Hi, and welcome to this virtual home sellers seminar series. I'm Gerine Skamarak with the Gerine team at Exit Realty East Coast, located in Holmdel, New Jersey. And I welcome you all again to this week's series. Just to recap, I've been doing this for the last month or so that I can educate sellers who are thinking of putting their home on the market that the market's really fantastic at this point for you. But what do you do to set yourself up for success? And in the past, a few of the episodes, we've had a home stager. I've talked about our professional photography, a home inspector, a mortgage lender. And tonight I have the pleasure to have one of my colleagues that I work with quite a bit is Andy Krantz from, he's a partner with Zager Fuchs located in Shrewsbury, New Jersey. And Andy's going to educate the sellers not only about why he's important to represent you on the seller side, but also the integral part of being a representative for a buyer as well. So Andy,
Thanks,
welcome.
Thank you. Thanks for having me. I appreciate that.
Good, good. So
nice to be here.
Good. I'm glad you're here because I think there's so many parts of selling the home that people don't even realize why it's necessary to up front, when I meet with my clients and we're preparing to list their home, it's not just getting the home for sale, but the process of what to expect. And once they sign up to list the home, I want them to also start to decide who they want to choose as an attorney and why it's important to have just an attorney that does strictly real estate versus a litigator or someone like that. Who's in court maybe most of the time or not.
That's exactly what I was going to say.
Yeah.
We prefer the attorneys who aren't in court all the time.
Yeah. So Andy, why don't you tell everyone a little bit about you
Sure.
and your background, and we can start talking about the process.
Sounds great. Well, thanks, Gerine. I really appreciate you having me here. And my name's Andy Krantz again. I'm an attorney in Shrewsbury, and I've been concentrating my practice on mostly transactions, residential, commercial real estate, probably for about 25 to almost 30 years now. And so I really just continue to work with buyers and sellers on selling their homes, their businesses. Also, I've done some estate planning for clients, but I really have always focused my practice on the transactional side of it because I've found from my experience that working with attorneys who are in court all day long and who are doing multiple different things, like they're the old time general practitioners, where they're doing municipal court, they're going to down to freehold to appear before a judge, they're doing a number of different things. It's very hard to in this day and age to also be available to your clients to do it for a real estate transaction, because in New Jersey, we have our process is much different than other states, and there's a lot of time pressure because of the way our contracts are set up.
And in New Jersey, a realtor is able to create the contract of sale, but at that point, once the terms are agreed upon with buyer and seller, it goes to the attorney review process.
Right.
So
Exactly.
we can talk about that.
Right. Well, because years ago, there was a court decision, and the Supreme Court in New Jersey decided that the realtors' contracts had to go through attorney review before they could be binding. So if someone had to have the opportunity, even though the realtors could write up a contract, they didn't want people to be forced into and to be stuck into a contract without having the opportunity to have legal counsel. It gives the realtors a lot of control to be able to at least get the deal locked in and tied up and the basic details worked out. But sometimes we do have other things that we need to consider as part of the transaction.
Right.
So
and protecting the client in
protecting the
different
client,
ways.
exactly.
Yeah.
Right. So when we normally get a contract right after it's been fully signed, we'll get that contract pretty quickly from the agent, and we'll start reviewing it for our buyers and our sellers. And often what an attorney will do is what's called an attorney review letter. In New Jersey, you have 3 days essentially to review the contract, and essentially you can cancel that contract at any point during that 3-day time period. So a lot of times you'll get a letter from a buyer's attorney or a rider amending the contract, and essentially they're saying they're canceling the contract, but it'll be acceptable provided we all agree to these conditions.
These other conditions.
And there are often things to protect our buyers and our sellers that we've found from our experiences.
And what you have to also realize is the 3-day period could last a little longer or it could be shorter. And
Correct.
in today's volatile market, since it is such a demand when you finally do have the multiple offers that have gone through, and we'll talk about that as well, we want to get that through attorney review to protect your agreement with the buyer that you chose, because if during that period another offer could come in, and if it's better, it could be accepted. So,
Right.
you know,
Or-
there's a lot of pieces that are moving parts, and if you don't have someone that understands that and you're working with an attorney, and if we decide, okay, Andy, we've got to get this through. We had a lot of activity. The seller really likes this buyer and this deal. Let's move this as quickly as possible so that we can get them under contract.
Correct, right. Well, and that's the thing. A lot of times you'll have a buyer who's maybe looking around, and then there might be other homes that come on the market, and a buyer may say, you know what, look, I've decided that
I'm out.
I'm out of this deal and I want to go on to something else. And so it really does work to the benefit of both sides to try to move
Yeah.
the attorney review process along relatively quickly. Sometimes it is to an advantage of a seller that you might want to drag things out, especially if you have a buyer, you have a contract. Typically if we get a contract on a Monday or a Tuesday, most often they're out of attorney review by Friday. Okay.
Yeah.
But sometimes when you have a contract that we get on a Wednesday or a Thursday, and the buyer side will send a review letter out, and the seller side may say, well, I'm really not loving what this buyer is looking for, and they might want to drag things out.
Yeah.
And as an attorney, we're going to know that, and we're going to be able to talk to the client talk to you about it,
Right.
to figure out, okay, do we want to see what else is out there? But keep in mind that another listing may come on the market over the weekend, and because we didn't get out a review on Friday with that client,
They may or may not be.
that buyer may decide to back out of your deal over the weekend.
So there's a lot of moving parts, and that's one of the also reasons that having someone that does just practice real estate is important. What I find is that we are a society now where everybody wants immediate gratification with something. So if they can't get a response because their representative, their attorney who someone hired is not available and didn't respond, that could really sway another deal coming in, and
Right.
they could be bumped right out or not. So it's really working with people that are professionals, that understand the process and are on top of things. If you are not working with a full-time person, realtor, who is not on top of their game, you may have someone that is working a part-time job and missed that whole delay and could have been a part of helping.
Of course, absolutely.
Contact the attorney to say, could you push this along, please? We really need this out today.
Right, exactly.
And these are important things. So that's one thing. These are questions you need to ask no matter who you hire to represent you. So once you're out of attorney review, what are some of the things that a seller or during attorney review that they don't realize that they should be aware of?
Well, I mean, the contract itself for one, it commits you to getting a certificate of occupancy.
Yes.
And often we found from experience, even though it doesn't come up that often, that we do want to try to limit the seller's exposure for the kind of repairs that they might have to make in order to get a certificate of occupancy. And so over time, we lawyers have developed and put in a cap on the seller's obligation
Right.
to make certificate of occupancy repairs. It doesn't really come up that often, to be honest with you. You probably, in your career, probably seen it a handful of times.
Yeah, a handful.
Where a seller has said, you know what, we usually use a number, let's say $500 or $1,000 or even more depending on the sale price. But when we put that cap in, and the cost may become like $10,000 in order to possibly remove a deck. We've had things like that where a seller says, I don't really want to do that. This compliance is beyond what I'm willing to do. It gives the seller to say, I'm out. If you buyer don't want to pick up the additional cost, I'm going to have to
or renegotiate
the contract. then I'm going to want to terminate the deal.
Right.
And so there's things that we've learned that we include. Also, a lot of times the buyers will ask to make representations about underground storage tanks,
Yeah.
and the sellers may say, okay, well, I have an abandoned underground storage tank on the property. And that's something that we may have to discuss with the client, because often in this day and age, abandoned tanks
it could be an environmental issue.
Could be environmental issues, and the seller may not want to have to address that, or may not realize that that's something that they have to take care of.
One thing I noticed in the last 3-4 years since COVID and the multiple offers, a lot of buyers are including in and asking their agents to include in that they'll limit inspections or they'll waive an inspection. How does that, since we're talking to the seller side right now, how does that, what does a seller need to be aware of if they accept something that's like that?
Well, I mean, I'm going to tell you the legal side and the practical side of it.
Sure.
Okay. I mean, and a lot of what we do is practical.
Yeah.
We have had these limitations in these contracts. I've had contracts where they just said the buyer's inspections are for informational purposes only, and then I get the attorney review letter from the buyer's attorney, and they have a whole host of things that the buyer is going to be inspecting,
Right.
and that the buyer has the right to terminate the contract. Well, my argument, if I'm representing the seller side, is, if the buyer did say that the inspections are going to be for informational purposes only, in my reading of it is that they're waiving the inspections.
Yeah.
And that if they want to have an inspection, go ahead, but they don't have the right to get out of that deal.
Right.
And that's something we're going to probably call to the attention of the client, or make sure that during attorney review, if the buyers put in informational purposes only, we're going to put in language that says the buyer doesn't have any right to terminate that contract.
Yeah.
Okay.
And that's to protect you, the seller, because that's your interpretation of what was presented to you.
Correct.
That could have been the reason why you chose offer number 5 versus offer number 3.
Absolutely.
And that's an important thing as an agent to convey when I pass that offer over to your attorney who's representing you. Andy, I always say, this is what was agreed upon, and this is why we chose this offer, so hopefully this will stick.
Right, exactly. And I mean, a lot of times we'll put in language in the contract that says it's strictly as is.
Yeah.
Well, strictly as is doesn't necessarily mean that the buyer is assuming responsibility to get the certificate of occupancy. And I've had situations throughout my career where that was assumed by the seller and the agent, but it wasn't sure that just a lot of what we do, and you often learn from your mistakes.
Oh,
or,
yeah.
I don't know if we want to call them mistakes, but you learn from people not really maybe always catching it or understanding,
Yeah.
or people being on different wavelengths.
Definitely.
And I think that's a big part of what we as attorneys try to minimize.
Yeah.
To try to get to the bottom line, just to see, okay, these are things that have come across our desk or our laptop, our computer before, and so these are things we're going to look out for our client to make sure that it doesn't happen to them.
And that's why it's really important to make sure that you hire an attorney.
Well, and the other thing when we talk about inspections is they'll also limit the inspections for structural and environmental purposes only. That's become a very common thing. But what does that really mean? In essence, a buyer's going to come along and they're going to say, well, the electrical box needs to be replaced. And we're going to try to argue that the electrical box is fine and it doesn't need to be replaced. Right. But in the end, a lot of times what I will advise a seller is that even no matter what we put into the contract, if you have a buyer that wants to get out of the deal, they're going to try to find every which way to get out of the deal.
Because what is the definition? Another colleague said, well, what is really the definition of this structural issue? Like, what if there's a crack in the frame of the window? Is that structural? Right. Is that
it's subject to interpretation?
And what I find is, although as a realtor, creating the contract, drawing up the contract, we are adding this language in, but I'm not an attorney, and we're using language that we think might sound good, but that's why the attorney review process comes in. They're going to protect you and make sure that if that's what you want, then this is what we're asking. If they don't want to do that, then this is not the right deal.
Exactly. And we're gonna advise you to give you the pluses and minuses of, is it worth, when you have a buyer that has come and had their inspections done, and they say that they just want out of the deal, even though under the contract the seller has the right to make repairs in the way the New Jersey contract is written. Sometimes we may not even want to know what the buyer's looking for. We may just want to say, fine, let the buyer move on, because as agents and attorneys and as sellers, you may have disclosure obligations that you may not have had if you never received an inspection report from another side, or a list of repairs.
Mentioning the disclosure, that is something new that's coming up as of March 20th. Sellers, you are required to fill out the seller's disclosure, and a part of that now is the state of New Jersey has provided us with a new seller's disclosure and a flood search and information on mold. So there are some things that are mandatory. And if you don't fill it out or you don't want to prepare it, you're going to have to sign off that you didn't want to do that, because we can't be held accountable that you're not going to fill something out that now is required. And this is by the state of New Jersey. I believe it was passed by Murphy or something.
It must have been signed into law by the governor. And
so these are changes and things that are happening, and you're not aware of it, but you need to make sure that whoever you're working with is aware of it, and that they're on top of all of these things that are happening to protect you as a seller. Some of the things you don't realize is you negotiate the contract. That's step one. You negotiate it again when you have inspections. You negotiate again through appraisal.
Correct, right.
And these are 3 times during the process that if you're not working closely with people that are on top of things and protecting you, and my job is to make sure the house appraises. So I want to make sure that the comps are there and that you accepted an offer that it will appraise. We're seeing such offers as list price or above, and it has to appraise if they're going to, we want to make sure that we're protecting you. Why accept an offer that's never going to see the light of day? That's crazy. The inspection part, limiting things, that's where you come in to make sure that it's not, hurting you.
And Gerine's going to remind us that, hey, the time period for the buyer to get their inspections done is coming up, or the time period for their mortgage commitment. I mean, we're both going to work together to try to make sure that you're covered. Those dates aren't forgotten. That you don't forget those dates, and that we follow up with the other side to make sure that they're complying with those deadlines.
And not following the deadlines. You have so much going on as a seller. You're relying on us to do that, and that's what we're making sure that the inspection's done within a period of time. If it's going to be, the report's going to come in, they have to have a response. We want to make sure that the deposit monies are in when they're supposed to be in. All of these little pieces are the transactional part of the deal.
Right. And it's a big part of what the agent does to help the process. I mean, we attorneys, when we go through the contracts and we get out of attorney review, we're now moving on to negotiating the inspection issues and and following up on those other things. But your agent often is the one who's really making sure that everything is moving forward to get to the closing date in time.
Right. And that's and the closing date, again, another part of the contract that is on or about, and I've tried to emphasize that on whether I'm working with a seller or a buyer. It's not a hard deadline date here. The difference, just every state is a little different. And it's an on or about. So it may be before or it could be after. It's as you get tighter to that period, you can see how it will benefit, or if you need to move sooner. Does the buyer need to move sooner? Do they need to lock in their rate, or their rate lock is expiring, or everything? There's so many pieces to the puzzle of this transaction.
Oh yeah.
So
we tell our sellers, don't book your mover until, have your mover lined up, but you can't necessarily rely on the fact that they're going to be closing. It rarely happens on that exact date because of all the moving parts, because of the inspections. Sometimes inspections may drag on for a longer period of time, and so we may have to push that out. And those are things that, as a seller, you may want to say, okay, before we wrap up inspection issues that now may have taken 3 or 4 weeks to resolve
Right.
with the buyer's side, which hopefully not,
Yeah.
but sometimes they do. But if it did take that much longer, well, we can't now, I'm not going to be ready to close in 10 days after, because that was the contract closing date. So, Andy, I need you to, talk to the buyer's attorney and, work out this date. This is when we're now going to be ready. And this is part of if we're going to agree to do these inspection repairs or these things, then the buyer then has to agree to this date for the closing.
Yeah.
So those are things we're going to
So
want to
you're
make sure that we're
constantly renegotiating little pieces of it, and
Correct, yeah.
it really is more than I think a lot of people realize.
a lot more.
And I think that what I've learned over the years is that I want to make sure I'm bringing you through each section and we're completing it. And we're closing that out. So you're closing out the inspection contingency clause, the mortgage contingency, this, that. Because if you don't, that could be somebody's out. And I've had a deal fall apart the day before closing because inspections were not agreed upon.
Right.
And it was it. And it's those little nuances that have brought me to these seminars and things that I'm trying to educate you. I know I've been through things and I'm still learning every day. I learned something today on a new listing that I'm taking, on a new construction that I was not aware of. And I said, well, you know what? That's what I like about my job. I'm learning still. So
Yeah, exactly. Well, and one of the things we find out is, and that throughout my career, is the deposit monies that we collect. It is very rare that sellers ever get to keep any deposit monies.
I'm glad you brought that up.
Because the contracts, the way it's written in New Jersey, the buyer has multiple outs. If we can't come to terms on the inspection issues, they can get out. If they can't get a mortgage commitment in time, or if the mortgage has contingencies that they can't satisfy, they can get out of the deal. There are opportunities for the buyer that don't necessarily often exist for the seller. And sellers will say, okay, well, the buyers now they didn't get their mortgage, and I'm now already rented a house, and now I'm out of money because I've rented this house, or I've already put a contract in on another house. What am I going to do? And unfortunately, I have to tell the client that there really is no recourse. That's the whole idea behind a contingency.
Yeah.
It's contingent, and if a contingency can't be satisfied, your buyer gets their deposit monies back, and you really a seller rarely gets compensated.
Correct. And I think that's a little bit of a misconception. We do have a lot of buyers moving from New York into New Jersey, and that process is totally different. It's like the reverse of what we do here in New Jersey.
Yeah, exactly.
They do all the work beforehand and then do the contract, and then here in Jersey we do the contract, and then all of this work follows. So it is a little bit confusing, I think. Am I wrong? Do they get to keep deposits in New York? I don't know.
I mean, definitely it wouldn't be over inspection issues, I wouldn't think. I don't know.
Because they do that ahead of time.
Because they do that ahead of time.
Yeah.
And, and they have the opportunity to extend out deadlines in New York much differently than in New Jersey.
Yeah.
But a lot of times people will say, I spoke to this person who's an attorney elsewhere, and they said, I should be able to get the deposit. And unfortunately, like I said, I mean, I've been doing this for 30 plus years, and
it's not
it's very rare that the seller gets to keep the deposit. It's only if the buyer willfully terminates the contract and is negligent or fraudulent might you be able to retain some of the deposit.
So then, regarding the deposit, as another question, a lot of times sellers will say to me, well, how much is that a good amount of money for them to put down, or and they're not really sure. I try to explain, well, they're putting down maybe 20% or 10% because that's what their mortgage product that they're trying to get. Is there a magic number?
Well, what I found was years ago, a standard deposit used to be 10% of the purchase price. And that would be, and that's something we'll often see and want to push for when there's a cash deal.
Okay.
10% because when there's a cash deal, the seller needs to really come up with most of the money for the closing.
Yeah.
And so we want to see that they're legitimate. And it's really, like I said, it's rare that a seller ever gets to keep the deposit. It's just showing that the buyer is committed to the deal. And it's also because that money's being held in a trust account, if the buyer does try to play games or does try to do something that's fraudulent or just say I've just decided I don't want to proceed with the purchase with no explanation whatsoever, then at least we have some sort of recourse or some sort of it gives us the ability to try to push them towards making either some sort of settlement so that they get some of their deposit monies back. And so that's really what the deposit is. So you want it to be able to hurt at some point.
Yeah.
So at least they're committed to the deal.
Skin in the game.
They have skin in the game is the perfect way to say it. So I have found that over time, when in a number of deals, a lot of times we'll take whatever they can get because but in the market we've experienced over the past few years, I think a seller pushing for like up to a 5% deposit, a 5% of the purchase price is probably a legitimate number, a good number to focus towards.
And you know, the deposits, you know, are held with usually the seller's attorney or the title company, depending on how they agreed on in attorney review.
Right. But I've also often said that, you know, you'll get a contract, and as the seller's agent, it may have a deposit of only $5,000 on a $500,000 purchase, and my advice to a seller is, don't sign the contract. Change it before you sign that contract.
Okay.
Don't rush to get it into get it signed.
Right.
If it's something if it's a condition that's important to you as a seller, you should make sure that your agent includes that in the contract. So look at that deposit, look at what those other provisions in there. And the most important things, not everything should be written into the contract, because that, like Gerine said, they're not looking to do legal work, but we are looking to make sure that the important things to you as the seller are in there.
Right. Well, I think we covered quite a bit of things. Yeah. There's so much more of the contract that could be gone over, but the process, as you can see, has a lot of transactional parts to it. And the reason that it is really important to have an attorney is to look for your benefit, to look out for you and protect you through the process, so that if something comes up that isn't really flying in the right direction one way or another, it's going to get negotiated, renegotiated, or somehow solved. And that's what we're all trying to do, is look out for your benefit. So if you have any questions, I'm sure that it would be great for you to give your information, because I don't know what. The handout. Oh, the handout. Oh, yes, I'm sorry. The handout is on my website. We have some information on both selling and buying that Andy has provided. So go to thegerineteam.com and look for that information. All of the other seminars had also checklists and information as well. But Andy's information, if you just want to call him and go over some of the things that we spoke about today, or that you wanted maybe some more information on, or a further explanation, I'm sure you would be happy
more than
to provide.
happy. Please give me a call. Also, I mean, and if it's real estate questions, we'll conference each other in, and we'll try to answer all those questions for you.
And your number, why don't you give me your phone number?
My office number is 732-747-3700, and it's we're on Avenue at the Commons in Shrewsbury.
Great. Well, thank you again for joining, and we look forward to next week. We're going to bring on our title partner at Kelly Title Group. And we look forward to hearing you more information on preparing your home for sale. Again, if you have any questions, you don't have to wait till next week. You can ask me at any time. You can call me at 908-902-4778. You can go on my website. You can message me, or on social media. I'm very attainable. So thank you, and have a great night. Bye-bye.
Thank you.